Welcome everyone to the Climate Litigation and Liability session. I am Ellie Mulholland, the Director of the Commonwealth Climate and Law Initiative, and I'm also on the management team of the Oxford Sustainable Law Program, and the CCLI and Oxford SLP are delighted to co-host this session. Shortly we'll have an expert panel hosted by the Director of the Oxford Sustainable Law Program, Thom Wetzer. And there you're going to hear that climate litigation is so much more than just that strategic litigation against governments and corporates. It is litigation in a warming and transitioning world, all the disputes that are going to come out of that. But there's also this thing called strategic litigation, and keeps getting write-ups in the FT and on the news. And so it's a thing, and we don't want to talk about it in the abstract. And so that's why we are delighted today to start with a conversation with a climate litigant. And we're going to have a chat about what's going on and why sue your government. So I'd like to start with a question for you. What were you doing when you were 16? I know I attended my first music festival, which makes me sound really cool, but really I was probably just more juggling my homework because I'm a massive geek. Wherever you were and whatever you were doing, I am going to bet $100 that you were not suing your government. But Linus here was. And so I'm delighted to introduce you to Linus Steinmetz from Germany, from Fridays for Future Germany. And he is a claimant in some landmark climate litigation against the government that found that Germany's climate law was unconstitutional, so the government had to go back and rewrite it. So Linus, welcome today. Congratulations on the case, and congratulations on getting your high school diploma.
Thanks.
So Linus, could you tell us about yourself? Where are you from?
Yeah. Hi. Originally in 2019, I was just a 16-year-old high school student from a small university town in Germany, Göttingen. It's quite similar actually in size to Oxford, so this is how you might imagine it. And I was a youth worried about the climate crisis and not really knowing what to do. So I started demonstrating and I started doing climate activism besides school. So we started to organize protests in 2019, trying to push for a new climate protection law in Germany, which is how everything sort of started.
So you're protesting in the streets, taking Fridays off school, striking, not just not going to school like we were in in our youth. You got the law, and then you sued the government about the law. Can you tell us about this case?
Yes. So essentially, our strategic goal as climate civil society in Germany was to achieve an ambitious climate protection law. And the issue was that we had a climax of 1.4 million demonstrators on the streets in September of 2019, and also at the exact day where we had these massive demonstrations, we saw the preliminary passing of this law by the German cabinet. But everybody was aware from the start that this law was detached from scientific reality. So the ambitions that were articulated, the goals for reducing greenhouse gases were so far from the necessary measures that we need to reach a 1.5 degree or at least 2 degree path. So this is essentially why we said we need a toolkit. We need something else than demonstrations. And so we reached out to climate organizations and NGOs who were already involved in lawsuits, and they reached out to us, and so we formed an alliance trying to connect activists and NGOs to litigate the German government.
So you challenged the government, and the case that we're talking about today is Neubauer against Germany. So Luisa Neubauer is the lead claimant, but you were there as well with your organisation DUH?
Yeah.
And you sued the government, and the case was particularly around the human rights impacts. Do you want to talk about those?
Yes. It wasn't an accident that I, as a back then 16-year-old, started this litigation because, as in most democratic societies, youth, as all other members of society, have basic rights. And these basic rights, for example, are the freedom to choose to pursue their life goals, to pursue careers, to live where they want. And we were arguing, among other things, that these freedoms that we were guaranteed by our basic law, as good as constitution, that these weren't able to be fulfilled because of a lack of ambitious policy.
I find that really interesting. I was so surprised when I was reading the statement of claim years ago. Good luck to you, arguing the human rights impacts were not the impacts around the flood, the heat events, the Philippines Human Rights Inquiry looking about the human rights impacts of climate change. We think about them, the physical risks, but actually your main claim was the human rights impacts of delayed climate action. If we know we have a carbon budget, then that necessarily means that the policy levers are going to be so much steeper later, post-2030, under the climate law. Yeah. So they're the impacts you're talking about. Yeah,
so this is also quite interesting about the case, as in a lot of other circumstances, that this generational aspect to law has, in this case in Germany, really been put to the forward. So essentially, we weren't suing about the freedoms that we had at the moment. We were talking about the right to plan our lives freely in the future. So the right to live freely in the future.
So what did the court find?
Yeah, we were actually really experimental in the way that we developed this case together with our lawyers and with the NGOs that supported us. So we were actually really terribly surprised to have a almost full-on victory at this constitutional court case. So the court essentially said that the government, in their ambitions, so in their declared goals on when they wanted to reach and certain targets when it came to greenhouse gas emission reductions, that these were unrealistic because essentially they were pushing they were kicking down the can down the road until a point where was reached in 2030 or sometime after that, where we would have to decrease emissions so rapidly that our modern society wouldn't actually function. So this is essentially the point where they said, you've got to readjust and you've got to have realistic and ambitious goals when it comes to greenhouse reduction.
So the court told the government to go back and redo the legislation. And so you challenged the 55% emissions reduction target by 2030. And the government went back, rewrote the law, and it's now 65%. So all of this talk today of the past few days, governments need to do more. You made them do more, and they did. So they've got this updated ambition, 65% by 2030. They've got some targets around 2031 to 2040, because that was really key. That couldn't be blank.
Yeah.
But mic drop, Linus has sued them again. Can you tell us about that?
Yes. So one of the big issues that comes with governments declaring ambitious goals when it comes to when they want to reduce emissions by some percentage is that these can't be detached from actual policy planning. But in the German case, they are. So there is a big improvement because of our lawsuit in the ambitions on paper, but there is no real adjustment in the way that policy is being made up until 2030. So we can't, for example, have a very late coal exit in Germany while still saying, okay, we're going to be almost climate neutral by then. So we are essentially saying you can't have the one without the other, and this is why we're building on our first lawsuit.
Terrific. And this one actually has Linus's name. He's the lead claimant, so watch out for Steinmetz against Germany. That's one to watch. There was much more follow-up, though. So something that we see happening is this idea of the cascade effects, where strategic litigants sue governments, and if it's successful, then look at the legal theory, the analysis, and say, well, let's test to see to what extent those obligations, those duties, and therefore breaches apply to corporates. And we've seen that in the Netherlands with the Urgenda case and then Shell. And so now we have an explosion of climate litigation in Germany, and it's also against the corporates. Do you want to tell us what's happening there?
Yeah, so there are very clearly identifiable emission-heavy industries, like, for example, car manufacturers in Germany, and this is why organizations like the DOH are suing the car manufacturers because of the impact that they are having on our generation. So, and also they are having impacts, for example, in the Global South right now. This can't be, even though this is not what the lawsuit was focused on in our case, we also discussed that, but there are real impacts today and in the future for people all around the world, and this is, for example, why VW and BMW are currently being sued in terms of strategic climate litigation. The goal of that, however, is to shift the entire industry's outlook. So just to make clear and make it possible that there are counter-incentives to fossil incentives that are currently still in the room, still existing for car manufacturers, and we wanted to kind of develop a counterweight to that.
Mm-hmm. So you're now challenging the automotive industry and also the energy industry with cases against BMW, Wintershall and BMW and VW.
Yeah.
So they're cases to watch. You mentioned that there's claimants and lawsuits going on in the Global South. So this is not just a European issue. We know that climate impacts affect particularly the most vulnerables within and across societies. Do you want to tell us about some litigation in the Global South? And I understand there was some claimants in the Neubauer case that were from some countries?
Yes, exactly, because this is often neglected, but we were trying in 2019 to develop different approaches to climate litigation against, like in the constitutional context of Germany. So there weren't only young people like me, there were also litigants who were from Nepal and from Bangladesh, because they are being affected right now and their livelihoods are at stake. They didn't succeed quite in the way that we did with our claim about basic rights for German youth, but because attribution research has so far progressed, it is possible, and the German courts also affirmed that the German government has direct co-responsibility for these people. So this is why there's more and more claims also coming into that direction.
Super interesting. So you've sued a few times. You've got the Global South litigant. Can you share your experiences? So you work with lawyers. Who funds this? What happens with these cases?
Yeah, I think the key to the way that we are going about climate litigation is an alliance of experienced lawyers who have been working on that for far longer than I have been involved in climate activism, or maybe even longer than I've been going to school, incidentally.
You've been alive, let's be honest.
Yes, probably. But there's a lot of expertise already in the legal field, and we tried to utilize that, and we tried to link up these rather political and organizational elements that we could bring into the room with NGOs who were supporting us also financially, because lawsuits and paying lawyers, even though many are working pro bono, this is still has a financial aspect for civil society to it. Nonetheless, this kind of coalition actually worked really effectively in Germany, and so it does, for example, also in the Netherlands.
So we're seeing it all over.
Yes.
So your story with this, particularly with this big lawsuit, Neubauer against Germany, it shows that the unlikely can very quickly become the reality. You got the German government to write the law, and then you quickly got them to say, it's not enough, change it again, in the space of a few years. I'm wondering if you could share some of the initial reactions that you had to your claim from lawyers and policymakers, governments, the people who wrote the law, and you're like, we're now suing you to say it's not enough. Yeah. What were the initial reactions, and how did that change when you were successful?
Yeah, I think it's quite interesting to see both the private sector and the public sector reacting in actually quite similar ways as soon as we won the court case, because the German government and the people who wrote the law very quickly ended up saying, okay, of course you were right, and this is a monumental decision, which of course is absurd and is a point where we go demonstrating again and point out that this is absurd, but especially the financial industry and the private sector in general were really interested, because they, for one thing, understandably don't want to get sued. Yeah. And on the other hand, we could deliver a prospect on, okay, what are our thoughts and what would we do in your position to not get sued, because there is constructive solutions that lead to a lesser risk of climate litigation.
So could you go into a little bit more detail about those responses from the corporate and the financial sector? Were they uniform, or were you hearing different things from different actors?
Yeah, I think they were principally similar, but there was still some diversity to it. So in particular, the financial sector was quite interesting because especially small German banks realized that this was not only a strategic risk, but also a strategic opportunity to be first movers and to try to make good financial decision-making while also trying to look out for the common good. So we essentially tried to kind of guide them in the way that we were thinking climate litigation in Germany would continue. Bigger banks, on the other hand...
Could I just pause? So smaller German banks have said, thanks 16-year-olds for helping out our business models.
Surprisingly, yes. Yes. So,
terrific. And the bigger banks, what happened there?
The bigger banks were more skeptical, also due to, I think, institutional differences. But essentially, what was interesting is that in comparison to the energy companies, who've got a very set business model, there's volatility in the financial in the financial business as in general led to many banks being much more adaptive than, for example, energy companies. So this is why the talks with the financial industry were usually for us surprisingly constructive.
And what about with the corporates, the real economy actors, particularly those high emitting?
Yeah, that's actually quite a difficult case because they have been doing similar things for a long time and have done, in their perspective, a good job. And what we are doing now is undermining their very identity. And it's not only about their business strategy, but also their corporate identity. So, for example, there's a much bigger gap culturally between, for example, the car manufacturers in Germany or the old coal companies in Germany and us as litigants and also as activists. So
the litigants and activists are here, and actually you're closer with the many financial sector actors than the some of the real economy corporates.
They've got more of an open ear, I would say, and also because it's just much more viable for them to quickly shift strategies, and this doesn't mean that there's no risk in the financial sector to not get sued, but it is easier to adapt, because if you are a company that is 100% reliant on fossil fuels at the moment, then it is quite difficult to quickly adapt your business model. Then the litigation is quite likely to come in anyhow, but in the financial sector, we actually have this image of the moving sheep. So usually the general public thinks of banks and financial institutions as very powerful and therefore also very influential. But we realized due to market dynamics, it's quite easy to get banks to be the first movers.
If you are a bank in the room, Linus did not just call you a sheep. It's fine. I want to put to you this idea that if you strategic climate litigation against a corporate defendant, because you necessarily can't sue everyone, you're picking someone out, it's unfair. What do you think about that?
Well, I think in democratic societies, suing corporations as well as suing the government is a basic tool of civil discourse, and there's a reason why most corporations have a lot of lawyers and have a lot of resources for legal departments, because lawsuits between companies and between individuals and companies have been going on as long as there's an established legal system. So it's
not the first time I've been sued for something.
Exactly, and it's not punitive. It's really much more about our goal to shift entire industries into a carbon neutral direction. So it's not about going after individual companies. Sometimes there are actors that are standing out, and we are trying to look on whether this is actually lawful. But this is exactly how the system is designed, and this is also how the system is designed with regards to human rights and a lot of other areas where lawsuits against corporations have been normalized and are not controversial anymore.
That's a good point. Okay, so we've got an audience here of financial regulators, asset owners, asset managers, banks, academics, lawyers. What can they do? What can they do? What must they do? What should they do about the kind of strategic climate litigation that you're involved in?
I think the task is surprisingly simple, because in my opinion, in the long term, if you look at long-term viability, there is both the opportunity to not get sued by shifting early towards renewable energies and to just divest from any kind of fossil fuel heavy kind of activities. This is surprisingly this is surprisingly good economically as well. We've discussed that in other sessions today. So incidentally, if you invest in big gas infrastructure today, the likelihood, at least in my opinion and from what I heard today, the likelihood of that being a stranded asset in the end is surprisingly high. So if you are reasonably afraid of climate litigation that might hurt in the short term, it is really, really viable to just shift away from any kind of fossil fuel as soon as possible.
So that's in their business activities, investment activities, operations. Would public statements of support of climate litigation be helpful?
I think the litigation itself fulfills a very particular role, and in our system as we understand it, as plaintiffs, we don't need support for lawsuits, we need lawyers. so I think the best reaction by companies is to go forward, publicly support also what we're doing, but also say, okay, this is what we're going to do about it, even though we are not right now being forced to legally, because this is essentially the way that cooperation in this area, I think, works best.
Get ahead of the curve before
Exactly.
government regulation changes or before you're sued.
Yeah.
Okay, so I have noticed today that you're 18, you have, as youth, we've brought the youth into the room, you have so much moral authority, but you also flew here, so I want to challenge you on that.
Yeah, I get asked that a lot, and that's actually a really difficult question, because I think if you can avoid anyhow not flying to your location, this is the best option, and everywhere I'm traveling where I cannot, where I don't have to fly necessarily, I won't. But in the big scheme of things, and for example, when you look at the probable and the actual reductions in greenhouse gas emissions due to lawsuits, or maybe some of you divesting fossil fuels from your portfolio, this is not in any way comparable to one flight. So I guess in that sense, we've got to talk much more about the big tools where we can get big emission reductions, and maybe we can, maybe we have to take into account that there are some small additional emissions for that.
Terrific. Okay, so you have sued your government a bunch of times, and you've just graduated high school. What next for you?
That's a good question, because I'm not sure, but our generation is at the point where we are starting to get into university. We are looking for ways to actually constructively participate in this path towards decarbonization. And for me, I'm probably going to start university next year and see where I'll end up.
I think you need a gap year first.
Yeah.
Okay, thank you so much for your insights today. I was about to say over to the experts, but the level of sophistication with which you've spoken about the transition finance and the shifts in the real economy has been phenomenal. So I think we're already here with experts. So thank you so much for your insights. I think everyone here will take away just how much the strategic litigation is achieving, how aligned the goals can be with particularly financial sector actors, and that it's not going to go away. And for that, I will say thank you. And over to the Director of the Oxford Sustainable Law Programme, Thom Wetzer, who'll be leading our expert panel.
Thank you, Ellie.
Thank you.
Okay, well, it looks like we're good to go. Thank you so much, Ellie and Linus, for that fascinating conversation. And I think what this conversation shows is that litigation on climate grounds, whether it's against governments, against companies, or against other entities, is actually far more organized, better resourced, and much more advanced than many people would imagine. And so what we're doing now is we're going from that one particular case and that one particular quite extraordinary litigant to look at the climate litigation field more generally, and also ask the question, what does all that litigation mean for you, for people who are operating in the financial markets, regulating financial markets, studying financial markets. And we're going to do that with this quite extraordinary panel. We have 5 panelists from both academia and practice. So from your left to right, we have all the way at the back, Sarah Barker, who's a partner and head of climate risk governance at MinterEllison. We have Catherine Higham, who is at the Grantham Institute at the London School of Economics, and there coordinates the climate change laws of the world project. We have Dr. Javier Solana, who's a senior lecturer at Glasgow University. We have Vesselina Haralampieva, who is a senior counsel at the European Bank for Reconstruction and Development. And we have John Firth, who is a senior director of the Climate and Resilience Hub at Willis Towers Watson. So thank you all for being here. The way that we're going to run the next 45 or 50 minutes is that we want to cover 4 main themes. So we want to understand what climate litigation means as a financial risk factor. We want to understand the efforts that are currently ongoing to price that risk, so to quantify that risk and to better understand the impacts of this financial litigation. Third is we want to have a sense of what's ahead in terms of where litigation is heading now. And finally, we want to talk about risk mitigation strategies for those who might be the targets of such litigation. So before we open the floor, I want to give each of the panelists an opportunity to briefly speak, have some opening statements telling us what they see happening in this space from their perspective, and then we will open the floor also for questions from you. So if you have any questions, write them down, but hold your horses. We're going to get there soon. So maybe Sarah, can I ask you to open the panel?
Thank you, Tom. Hello, everyone. Is my microphone on? Yep, ish. That's better, thank you. I just wanted to start with a controversial opening remark, far be it from me to do that. Climate litigation is actually a misnomer. There is no such thing as climate litigation. It's just litigation. And to understand that, it helps to think about climate change. What are its impacts? What are its consequences? What is the nature of climate change? So what do we know about it? It's a financial risk and opportunity. It causes damage to people's health, to people's well-being, to people's property. It causes economic loss. So therefore, what are the legal consequences of failing to manage those impacts of climate change? Let's think about what that means for a financial institution. And it's not just in terms of the direct climate litigation risk to you as an institution. It's also what does it mean for the companies to whom you lend, in whom you invest, and the financial systems in which you operate. So thinking about those direct impacts for financial institutions, how can you be sued for a failure to manage those broader climate impacts, not just for causing the emissions, but for failing to manage the financial risks and opportunities in particular? Well, we had a whole panel yesterday about greenwashing. Greenwashing is basically just misleading disclosure or securities fraud in a climate or environmental context. That is a huge risk. In any of the financial institution clients, if I'm in their boardrooms, if I'm talking to their general counsel, that is focusing the mind at the moment. The risk of over-promising on climate risk management or understating the rest of your business. If you're on a board of a financial institution, you can be sued for a breach of your duties to the institution, your fiduciary duties, breaching your duties to act in the best interests, financial interests of your institution if you fail to manage these risks, or a failure to exercise due care and diligence, to be competent in understanding what the risks to your institution are and to managing those. So of course we've got those direct risks to institutions. But then there are secondary risks. There are risks to the companies in which you invest. And believe you me, litigation ain't cheap. Reputationally, management time and effort, let alone legal costs, let alone any damages award. This has direct financial implications for the companies in which you invest. That can have contagion across your portfolio in particular sectors. And I think, Kate, you're going to talk about some of the areas in which, more broadly, investee companies might be sued. And then finally, we have tertiary impacts. So a lot of these cases, like the amazing litigation that Linus has been involved with, I don't know about anyone else, but did anyone else feel really dumb? Listening to what 18-year-olds are doing these days. Anyway, those tertiary implications, those kinds of framework level cases can shift entire systems, can shift laws, can shift the way that markets operate. So we've got direct impacts, we've got secondary impacts, we've got tertiary impacts. This stuff can move economies and move markets. So when we're talking about climate litigation, what is it? It's using the law to move markets.
Thank you, Sarah. Kate, over to you.
Great, thank you for that, and thank you, Sarah. I'm going to pick up a little bit on where Sarah's left off, and the first thing I'm going to talk about is just a little bit more detail on what we mean by the kinds of lawsuits that companies in particular could be facing, and a little bit about how we need to think about these government framework cases. And then I'm going to ask a question, which is, what do we know about whether or not financial markets are actually responding in the way that we, as lawyers studying climate litigation, think they should be? So on that first point, the two kinds of cases against companies that I think are most important to consider are cases involving claimants seeking compensation for direct causal contributions to climate change. And these are against the highest companies in the highest emitting sectors, oil, gas, and cement. So that's pretty obvious. Most of you probably would have heard of those. The other kind of case that I think is very important to think about, and particularly when we're thinking about the fact not all litigation is strategic, are cases against companies who have failed to adapt their physical assets to climate risks, and where those physical assets may rapidly exacerbate the impacts that you see from an extreme weather event that's attributable to climate change. So that is an area that I think is probably pretty under-considered right now, and something which people should really be looking at more. The second thing I want to say is about these government framework level cases. And I think this is really important when it comes to transition planning, a conversation that we've been having throughout this conference and about which there was a lot of discussion yesterday in particular. You know, when you are, as a company, as a regulator, developing scenarios to consider what the transition looks like, you need to think about how litigation could play in, either as an amplifier of the transition, like the Neubauer case has been in Germany, like the Urgenda case has been in the Netherlands, where you see many more policy actions being taken on a much more rapid timescale, but also litigation as a potential delayer of the transition. And many of you will have seen the news about the West Virginia and EPA case coming out of the US Supreme Court recently, which limited what the EPA can do to regulate greenhouse gas emissions. Now, by far not the end of the story. There's lots that can still be done, but it does show that this is something that we really need to consider when we are trying to make predictions about what will happen in the policy space. So then finally, I want to talk a little bit to this question that we in the academic world are only just starting to really grapple with, of whether or not we can say that financial markets are actually responding to climate change litigation risk. And we can talk about two papers, and this is how kind of early this field is. Both of them are still working papers. One of them isn't published anywhere, that are trying to use event studies methodology to understand whether or not climate change litigation actually impacts on share prices. Is it being considered by market actors? The first paper is a paper I'm working on with some colleagues at the Grantham Institute, where we're looking at whether or not litigation against companies, the filing of a case against a company, appears to impact that company's share price. And our preliminary findings suggest that in the very early days of climate litigation, so back in the mid-2000s, there was an impact when cases were filed, and these are a couple of big cases in the US, particularly Kivalina and ExxonMobil, that there was an impact, that people were worried. They thought, okay, what's going to happen here? And then those early cases were lost, and the markets went to sleep on this issue. And they said, well, this is put to bed. This isn't a risk that we need to think about. And only recently are we starting to see an uptick in correspondence between cases being filed and impacts on share prices again. So I think that's quite important to bear in mind. And the other paper is a paper by a guy called Eric Voeten, who has applied the same kind of methodology to cases against government. So Linus's case is one of the ones that he's looked at. And again, he finds that there is a small but significant impact on share prices in companies in high-emitting sectors after these cases. So some engagement with climate litigation from financial markets, but we would argue that there probably needs to be a lot more. Thank you.
Thank you, Kate. So Kate and Sarah, you have both given us a bit of a sense of how to conceptualize litigation risk and what different types of litigation risk we're grappling with. Kate, you've given us a sense of one way, so econometric analysis of share price impact, that we can estimate the financial implications of this type of litigation. Javier, I want to ask you, can you reflect a bit as well on how we think about the impact of these cases in a broader sense?
Yeah, and maybe I can start by framing a little bit the discussion, because I think there are some ideas when we talk about the cost of climate litigation for non-financial and financial companies that somehow lead us to underestimate the potential costs arising from these cases. So many of you will have heard the word liability risk, for example, and Sarah was saying climate litigation is a misnomer. I think liability risk is also a misnomer, because the term liability risk leads us to think that the main cost associated with litigation is the potential payout, the potential fine coming from a case that a client might lose. But in reality, as Sarah was saying, it is a lot more complex than that. There are obviously payouts and fines as an evident cost, but then you have legal and administrative costs, lawyers' fees, most evidently. You have insurance costs. If your insurer thinks that you're more likely to be sued, that might have an impact on your policies. There are financing costs if you have, for example, sustainability-linked products. And there are reputational costs. And this is just talking about the costs arising from cases directed at you. If we start thinking about the costs that you may suffer indirectly when others are sued, we're thinking about counterparty credit risk from your clients. We're thinking about market risk from the assets that you hold. We're thinking about insurance costs, reputational costs again. So this is really a lot more complex than just being asked to pay a fine or to pay compensation. The other important idea, I think, that comes from thinking about this in terms of liability risk is that these costs are only going to arise at the end of the proceeding and only if you lose. But that is really not the case. And let me just talk briefly about reputational costs, for example, which I understand arise at all stages of the litigation. I would even argue that they may arise even before the litigation begins. So Kay was talking about the impact on share prices of filing these cases. Even if there's speculation about a company being sued, that might actually trigger reputational costs. Reputational costs are also multifaceted. Share prices are an obvious manifestation of that cost, but we've also seen in the financial services industry loss of business, clients withdrawing their money from banks, for example, in the Dakota pipeline in 2018 in the US. We're seeing difficulties in retaining and attracting talent. So reputational costs are complex and multifaceted. I was going to say that another misconception around litigation risk is that it's only indirect. That is not going to happen to me, but I think Sarah has talked very clearly about the direct risks that financial institutions and their clients face. We can talk more about that in the Q&A if there's interest. The last point I will make is how difficult it actually is to understand these costs and to measure them. And I won't go into detail about the methodological challenges that one faces when one tries to estimate these costs. But just to give you an idea, a lot of this data is just not publicly available. We don't know how much money Shell is spending on lawyers. Anecdotal evidence suggests that they're spending a lot of money, but we just don't know how much. And another interesting challenge is that some of these studies that are being done are backward-looking, but I think that when it comes to understanding what may lie ahead, we're in the dark, because some of these backward-looking exercises might have been useful 5 years ago, but as we've been listening to several speakers over the today and yesterday, cases have exploded, and who knows where the next case might arise. Thanks, Thom.
Thank you, Javier. So a real complicated setup then, where costs can be both very significant, but also very complex to estimate ex post, let alone ex ante. So we have a real challenge here. Now, Vessi, you're dealing with these kinds of cases and the risks that arise from them on a day-to-day basis at the EBRD. And so maybe you can tell us something about how that works in how these risks are being taken into consideration when you're making decisions, but also when you're working with your clients.
Thank you, Thom. I will step back a bit. I mean, this is a fascinating discussion so far. I think what we heard is that climate litigation is a driver for climate action. It's a driver for climate action on the level of governments and on the level also of companies and financial institutions. I also want to talk about another key driver for this massive transformation that needs to take place at all levels of the society, and this is really access to finance. And this is what international financial institutions such as EBRD, where I work, provide. In terms of access to finance, what we see, we all see that, is that clients, companies that do not take account of their climate-related risks, both physical and transition, will find it more difficult to access capital. So if you are, as we have heard from Sarah and from Kate, so if you have inadequate measures, or if you misrepresent your climate targets or ESG credentials, you're facing also climate liability risks. So I think that these are very closely interlinked. Financial institutions are taking account of that. And just as an example, we've heard about the Network for Greening the Financial System, so NGFS, which is a group, a network now, a global network of central banks and financial regulators, who are really asking financial institutions, financial market participants to take a look at litigation risks. They have issued a paper last year. Now we're working together, EBRD as an observer, to update it and really look at the risk to financial institutions. So I'm not going to get into that because of the limited time. The risk for central banks, and there is case law already there because they have mandate and authority to uphold national climate policies. And from a financial institution's perspective, what really financial institutions should also consider is counterparty risk, so the companies in the sectors where they invest. So what we do at EBRD, we, together with our sister multilateral development banks, we have signed, we have committed to align our operations to the Paris Agreement. So you know Article 2.1c, aligning finance flows to low carbon and resilient development. For EBRD, as of January next year, all our operations will be Paris aligned. And we have to be very careful. We've heard a lot about misrepresentation. So this type of assessment is based on very strict methodologies. Just to give you an example, the one that was recently approved for intermediated finance, so the way we do business with our financial institutions, it comprises several pillars, but one of the more, and I would say, innovative pillar is for high-risk clients, we will start assessing the counterparty risks through all the facets of the way an organization functions, starting from governance, strategy, climate risk, that climate targets, metrics, their readiness, willingness to disclose. So this is really TCFD in action. But as a development institution, what we do is we want to really work with our clients to help them transition, because let's be real, 80% of our energy needs at the moment are powered by fossil fuels. Divest, we have seen the crisis, also geopolitical crisis that we've seen in Europe recently. But working with institutions, with financial institutions, with corporates, to develop credible transition plans based on science-based targets, help them develop the functions, the knowledge and the data which is lacking in the part of the world where we work. I think that that's a huge role and a huge demand. One other thing, sorry, just not to abuse my time, one other thing I wanted just to mention, because I'm working in a development institution, in addition to our investment hands, we also do policy reform. So we work with national authorities, we work with courts, with regulators, and in terms of managing and helping them to mitigate such risks, as we have heard, we help them develop and update their National Development Climate Plan, the NDCs, the National Determined Contributions, their LTS, Low Transition pathways, and sector-specific pathways. So this is more on the policy front. On the legal side, we also expect to work increasingly on climate laws, so turning these climate commitments into binding legal obligations. We've also started working with courts, so helping judiciaries in our country's operation uphold environmental rule of law. And there is a huge demand, to be frank. So we have seen many cases in the global north. You alluded to new cases in the global south, emerging markets, Southern Europe and Central Asia. I wouldn't say there are many. However, in our discussions, recent discussions with Supreme Court justices in this region, we really have seen their increasing awareness, interest, and recognition of the role of courts to hold governments and companies accountable for their climate action or inaction.
Thank you. So we're coming full circle in the sense that we're returning to the private sector now. And John, many of the people here in the room are, in the professional services industry. I know you have lots to say, but the one thing I really want to hear from you is, what does this mean for them?
I'll just go back a bit to context. I first started working on climate adaptation and resilience in 1992, so that's 30 years ago. 30 years ago, when I was in the water industry, as a professional, we recognised that climate change was a game changer for the business. The science was clear, the evidence was very clear, and as I once reminded a group of bankers, I knew more about which way temperature was heading than they did about interest rates over the next 6 months. Now, they didn't like that response, but that's true. Now, with that knowledge, what we realised was that the decisions we were making at that time were suspect. And the decisions we had been making for some time were suspect, because evidence was available, not just from IPCC reports and the academic science world, but if you look at all those who are members of professional institutions, I guarantee that at least from around 2000, your institution published a report about climate change and what it meant. So whether you're an accountant, an engineer, an architect, etc., you have professional guidance from your institution about climate change. Now, as a professional, your responsibility is not just to deliver on your brief to your client, it's to give best advice. You have a code of duty to them. So even if your client has not asked for, tell me about climate change, and for example, what will the changing effects of climate mean to the potential design and operation of the asset I'm asking you to design, even if they've not asked for that, you have a duty of care, and as a professional, to give them the best advice. So what does this mean? Well, in 2006, we wrote one of the very first Carbon Disclosure Project reports, and I talked about litigation and liability risk, because I saw it's the elephant in the room. Everybody was beginning to talk about physical risk, talked about mitigation then rather than transition, but nobody was talking about liability. And it just struck me that litigation was going to be the way people took recourse to damage. And as time goes on and decisions are taken about the design of physical assets, for example, and decisions are made, if they don't take climate change into account, all you've done is put liability on the balance sheet of your company, and it's also a liability on the balance sheet of your client. And it's sat there waiting for an impact, waiting for a risk to materialise, and at some point somebody will say, who made those decisions and on what basis? So my major concern, and say elephant in the room, is that everybody who acts as a professional advisor is at risk. And I know, for example, the insurance sector is looking very carefully at professional indemnity insurance and looking at director and officer liability, but this also cascades out into the wider client area as well. Just to emphasise how important this issue of litigation is. One of the big challenges for the developing countries is access to finance. And one of the big areas that the developed countries don't want to talk about is loss and damage and reparations for historic loss and damage. And discussions have been going on since 1992 on loss and damage, and they've got nowhere because the developed countries just don't want to accept responsibility for the emissions and then the impacts. I can see at this COP, possibly, COP27, the developing countries losing patience with this kick it down the road type response and start to look at, can we start to take action against large companies in the Northern Hemisphere particularly, but also against developed governments, and say there is a legal case for you to answer because you have allowed emissions to take place, knowing the consequences, we suffer, we experience the cost, you must pay. So trust me, litigation is the big issue. Just one last comment. About 7 or 8 years ago, I was at a conference in Colombia, and it was in front of a whole group of university students. And somebody said to me, with all this understanding of climate change and how it affects the world, what profession should I go into? I said, hand on heart, I said this, you should go into the legal profession because you're going to make a lot of money.
Yikes. Well, thank you, John. I want to open the floor for questions. So I don't know if there's anyone who has a question, but if so, raise your hand. I'm going to give 2 people the opportunity to ask a question. So there is one behind you, I think, right there.
Hi, yes, it's Lucy from Responsible Investor. Really fascinating discussion and something I didn't know very much about before. And so this may be a stupid question, but I was talking to somebody yesterday about, obviously there are a lot of people at this conference who are working on some very interesting data sets. And I was talking to someone who's saying, actually there's a problem sometimes getting that to financial institutions, partly because the financial institutions don't necessarily know what data they want, but also that maybe in some cases, they're a little bit worried about getting hold of some really exciting data sets in case it shows something that they don't actually want to know, and that could then potentially make them liable in future. Is that actually a genuine risk, do you think? I have no idea what it's reasonable to expect financial institutions to source in the way of information.
Thank you. So one other question right there.
Thank you. My name is Pavel. I'm an MBA student here at Oxford. Thank you for a fascinating panel discussion just now. My question is, I wonder whether there are any sort of boundaries and limits that you would like to see within that litigation space. So, who is best positioned to raise those cases, and against whom should they be raised? Because I understand that this is something that is growing, and it's growing at a fast pace. But, are we going to get to a point where your next door neighbor can sue you if you're driving a car which emits pollutions, right? At what scale are we talking about that litigation, and where is the right sort of balancing point? And linked to that is, my fear is that if this escalates and, if we have a lot of these cases, every real economy company will have to have an army of lawyers, and to your point just now, should we all become lawyers? And is that really the real good of the economy?
Thank you. So, Sarah, can I ask you to answer the first question about what it might be better not to know? if there is such a thing?
Thank you for not getting me to answer the second one. There's a principle under the Law of Negligence, and you use the word reasonableness. There is an obligation to take reasonable precautions against reasonably foreseeable risks of injury to someone to whom you owe a duty of care. That's all about what you ought to know and what you ought to have done. What would a reasonable person, institution, company in your position have done? It's not about what you do know. It's about what you ought to know. And I would doubt that there would be a court in the universe that would look at one of the tens of billion dollar market cap institutions or big pension funds around the world and say, we understand it wasn't reasonable for you to pay for this research, to understand these risks to your multi-billion dollar asset book. Just because they're too scared is not going to be an excuse.
What if it is some of this sort of solution of the really cutting-edge data sets that perhaps people don't actually know that they don't know what they don't know yet?
It's the unknown unknowns. They very, very quickly evolve to be known unknowns. Very, very quickly.
Right, thank you. Javier, you wanted to come in on this, and can I also ask you to speak to, do we want to end up in this world where everyone becomes a lawyer, and who should be?
Yes, we do.
I'm a law professor, so I would say yes. No, but maybe just quickly on the first question. I'm also working on this issue of reasonableness, and I think what we see is that it's not that expensive to get that data out there. It's already available for free. There are many civil society organizations pointing to very important issues, and financial institutions are aware of those issues. So I don't know to what extent they don't want to pay for this free and what they might find, but that is already available. So that is already exposing them to a lot of litigation risk. On the second question, it's a bit difficult for me to answer that, but maybe I'll just share a general reflection, which is one that I made when I started working in this field, and is that the most effective case is the one that doesn't reach the court. So if at one point we see companies worrying about this and changing their practices and trying to mitigate the risk of litigation, I think we might begin to think that litigation has been effective. So I hope that we don't reach that point when everyone is suing everyone, also because I think that would mean that the legal system that we use to order our society has failed us. So hopefully we won't reach that point.
Thank you, Javier. So I have many, many questions, but there are so many in the room that I'm going to just keep going there. So the gentleman there.
Thank you. Thank you, panel. Great panel, and also the previous conversation. I'm Henry Fletcher, European Bank for Reconstruction Development, working in land use advisory. Just a very technical question I'd love one or two of you to answer. On burden of proof and evidence. So my understanding of commercial law, not very deep, but is that to be awarded damages, you have to have incurred those damages. So I was intrigued by the success of the case that, as I understood it, hinged on future loss of opportunity. So, and also where those loss of opportunity is perhaps very uncertain, albeit within a range. So I guess if you could just address that briefly. Thanks.
Thank you. And then there's a question there from the gentleman in the boat with the bow tie.
Thank you. Wading into an area that I don't know, but
can you just hold up to?
Sorry, wading into an area that I don't know, but very compelling. So, pardon my ignorance in asking this kind of question, but a few years ago, I came across this idea of responsibility to protect, which I think is a quite profound responsibility to protect R2P. Is that in thinking about how litigation goes forward, is that a very ripe approach to such? And anyhow, when we're talking about developing precedent, is that kind of going nowhere, or is that a good place where precedent can be made?
I think we're going to leave it to one question, just because I want to give...
I'll stop, and thank you.
Thank you. Kate, can I ask you to come in on one of the two questions? You can choose.
One of the two questions.
Yeah.
So I might go with the question about how you can have a successful case when you're talking about what's happening in the future. And I assume you're referring to Linus's case, the Neubauer litigation. And this is basically about the fact this was a case against a government about a duty that they have, constitutional duties that they have to protect in the future. So you are making the case that what you are saying is probable, likely to happen, and then the court is able to, on that basis, to say that the government is acting in a way that is not compliant, not consistent with their duties, to take reasonable care to avoid those kinds of harms to the rights of citizens. So the question of causation in climate litigation is, of course, massive. One of the reasons that we've seen maybe more success recently than we have in the past is because we have seen more of these future-oriented cases. So instead of saying that what a government or a company has done has already caused X cost and they need to pay, correspondingly pay compensation for those costs, it's about what you are obligated to do to avoid foreseeable harms in the future. And that's, in many ways, an easier argument to make, and it's key to some of the recent successes.
Thank you. Vessi.
Thank you. I just wanted to comment on that predictability and what actions needs to be taken, and also quickly to refer to the previous question. I don't personally really agree with the fact that climate litigation will be so massive that you will need kind of crowds of lawyers and will be a super lucrative, well, it might be, but profession. But I think that's what we are here to say, that this is one of the key drivers. So it is really the risk of being sued. And the other thing from financial institutions is it's very difficult to measure this risk. I'm not even quite sure whether there are any instances of pricing it. I mean, the Bank of England has done some work and recommended for insurance in particular to start looking at climate litigation risks. But for banks, there is not enough data. We mentioned it's difficult to predict, but I think the reputational risks are tremendous. So how to then predict or how to mitigate is really to be, I think, and that's what it's important about what we do in our Paris alignment methodology, is to work with companies to start identifying what are their risks, how are they managing them, being really credible about their efforts. And I think that there are no answers. There are no necessarily answers on what will be the best case scenario, but having these credible pathways and supported by science-based targets and other initiatives out there, I think that that's definitely the way forward.
Sorry, Vessi, maybe just as a quick follow-up there. So Linus gave us pretty good advice, I think, at the end of the fireside chat, which is, basically be proactive and expect that certain behavior that we all know, to be the kind of behavior of the past, heavy pollution, investing in heavy pollution for that matter, that is going to be phased out. Is that the way that we should think about engaging with litigation, rather than lawyering up on everything that we do, just being proactive and seeing where the puck is going to go?
Definitely. I think that even if we look a little bit broader, like climate litigation, also including, for example, air pollution, there are also cases that have, in also the countries where we operate, indirect impact on carbon polluting industries. So even if there is not necessarily a cause of action, as we discussed in the climate legislation, the way forward, I think, is really being aware that there is not necessarily only climate litigation, as you said. There are other instruments that have been upheld in court about environmental protection that have direct and indirect implications on fossil fuel industries or others. But what I actually just wanted to mention is that what we have seen in the emerging markets, where lots of these multinational companies operate, is that there is this increasing consensus, I would say, I think you alluded to that, to choice of form and going really after not the subsidiary that is based in this jurisdiction, but in global north, where the case will be heard. So this is also changing the behavior in these countries where, let's say, legal systems are not that evolved or courts will not admit such cases.
Great. Yeah, John,
Can
you
I
want to
just
come
add
in
to
there?
that?
Yeah.
I mean, that's an important point, Vesselina. I think there's a really interesting set of litigation going on in Germany that's been going on for some time. But what's interesting about it is it's a farmer from Peru who is claiming, I'm not going to prejudge it, although I know what the answer is, claiming that his farm is suffering because the glacier is melting and it means his water supply is interrupted, etc., etc. And what did he do? He's suing RWE in Germany, who don't operate in Germany.
In Peru.
Sorry, in Peru.
Yeah.
They have no operations in Peru at all, but he's suing them in Germany. The reason is you put some emissions up in the air, emissions cause a problem. Therefore, there is a cause and effect. I don't actually have to prove they were your emissions causing it, because that's not possible, but you had an effect. And he's only suing them for 20,000. Now, the importance of that case is not actually that he will win. It's the fact he's bringing it to everybody's attention. And so when I flippantly said, you know, everybody be a lawyer, what I'm trying to do is point out you have to address the legal risks. You have to understand what these are. And for a company like RWE, who's partly claiming, even if we were operating in Peru, we'd operate against the regulations of that country. I'm sorry, that's not good enough. Because if you operate against one set of standards in one country, but accept a higher level in another country, you're accepting that you put a risk in the first country. So this is where businesses and their investors have really got to start interacting with their investments in a much greater way. And as somebody said before, this isn't actually about getting litigation. This is about creating change in the way businesses are managed.
I would say far from just focusing on the principle, though, and on the awareness that this case might generate. I mean, the fact that companies and potentially other entities too might be held accountable for the impacts of their emissions wherever those impacts occur, if that principle is established, of course, would mean having, you know, that all companies and portfolio companies too might be going through life with an enormous contingent liability on their balance sheet. So the practical implications of a precedent like that might actually be quite far-reaching too. So I'm going to take two more questions, and I'm going to insist on brief questions and brief answers, and then I'm going to ask each panelist to give us a one-line takeaway from this panel for the audience, so you can already start thinking about that. So two more questions. I'm going to take the gentleman in the back.
Thank you. My name is Piers Smith from Franklin Templeton Investments. So I just wanted to ask about the chilling effect of litigation. And investors for some time have been asking issuers to include climate-related disclosures in their audited financial statements, both in the compliance and voluntary sense. And there's a natural chilling effect on companies of the threat of litigation, making it harder to do that. Yet this inclusion of climate disclosures is incredibly important. For it to be filed and not furnish reports. But then it also goes both ways, because the way that investors have achieved this ask is often through collective action. And there's been a converse threat from companies to litigate against investors on violating concert party rules to achieve this collective action and asking for this. So my sort of question to the panel is, how can we appropriately manage that chilling effect in a way that still protects and promotes litigation as a really useful tool in achieving progress against these climate goals?
Great, thank you. The final question of today will be to the lady up front here.
Thank you so much for the very interesting panel. I'm Sharifa from, I come from Malaysia, work with the corporation there. Malaysia has got policies on climate change. Not a single case has been brought up under this legislation. Every year almost, we are grappling with haze and pollution issues from burning of palm oil. And if we wanted to litigate against Indonesia, Indonesia would say, hang on a minute, it's your corporates who run these, some of these plantations. And also, we're all very interrelated. It's not in our culture to litigate. We want to cooperate. So my question is, have you seen anywhere where this has changed in another emerging market? Or what do you think can drive this change? Thanks.
Thank you so much. So, Sarah, can I ask you to comment on the management of the chilling effect?
First of all, you need to call bullshit on the chilling effect, because that is a complete misunderstanding of the law as it operates. And I get that pushback from directors all the time. So, first of all, you think about what is their concern. They're concerned about making forward-looking statements that might turn out to be wrong. The law basically says you need to have reasonable grounds as at the time you make a representation for that representation. If you say nothing, if you don't take climate-related futures into account, what are you representing? You're representing that you believe the world will continue the way that it is. And if there is one thing we know is not true, is that the world today and tomorrow looks nothing like it did in the past. So actually in this area, it is a far higher risk to say little or to say nothing. You're also in breach of your disclosure obligations to give material information to investors if you're saying nothing, because what's the definition of material information in financial statements? What would an investor find decision useful? Is any of this stuff decision useful? Hell yes. It is the most material information for an investor. How are you going to thrive in a transition? Or are you going to be a dodo? So if you're getting that pushback, you need to call it out and say that misunderstands the law, and you're actually subjecting yourself to far greater risk than if you actually explained what your view on this is.
Thank you. So, and maybe, Kate, can I ask you to come in on the question about what happens in potential switches from a cooperative environment to a more litigious environment?
Yeah, I think it's a really interesting question, and I think the point you raise about the kind of culture of litigation, what is the appropriate way to use the law in different jurisdictions, is something that really needs to be considered. And it won't necessarily be this kind of adversarial strategic litigation that has worked so well in Germany or has just worked in the UK with the net zero case that we've just had. It may be something else. And so one thing I think is interesting is that we've recently tracked in a database that I run that tracks climate litigation cases around the world, a number of cases in Indonesia where the Indonesian government has been suing people who breach domestic regulation about where palm oil plantations can be and people who've exceeded their legal permits. And they're suing them, one, for exceeding the legal permits, but two, for damages associated with the carbon emissions released from the deforestation that has occurred as a result of that breach. So that's just to say, there's many different avenues and ways of thinking about this, and it's not going to look the same in every jurisdiction, and it shouldn't. And it's really important to think about those jurisdictional differences and what will be most effective.
Thank you so much, Kate. So we're going to turn now to the one sentence, and I stress one sentence, recommendations from you for the people in the audience. And John, if I may, I'm going to start with you and then go down the line.
I'm going to struggle with one sentence, but
you got it. You got to do it.
Yeah, I think the thing to take away from you today is not if, it's when. It's as simple as that. Litigation is an obvious recourse route for those who feel they've suffered loss or will suffer loss. That is going to be pursued.
Not if, but when. Thank you, John. Vessi.
In one sentence, well, I think finally, for all of us, climate change is ultimately a matter of human rights. It's a human crisis. And I think we need to understand that every part of the society, including companies and financial institutions, should consider all the risks, including climate litigation risks, if they don't understand that they have to have proper and adequate response to these climate risks and integrate credible transition plans and targets in their strategies.
Lawyers can have one sentence with lots of commas, but thank you very much, Vessi. That's very much appreciated. Javier.
Not a takeaway, but a prediction. The space to watch in climate litigation for financial institutions, I think, is duties of care, broadly understood. I think that's where we're going to see the next litigation in the financial system, duties of care.
Thank you.
And yeah, maybe just building on that, I think the key takeaway for me is that you need to stay ahead of the curve and you need to act before you're involved in litigation, because that really is something that you want to avoid.
Thank you. And Sarah?
I would say ask your General Counsel what analysis has been done on what the risks to us as an institution are from litigation and what the risks to our portfolio are from litigation.
Some wise words from some excellent panelists, so please do give them a round of applause. And I just want to end by saying this. So I think what this panel showed, if nothing else, is that this is a topic of growing importance, but also of vast complexity, and we're really at the early stages of getting to grips with it. I mean, frankly, Sarah, we don't even have a name for this yet that we can all feel confident about. And so, against that backdrop, what I'm very keen for you to know is that here at Oxford, and in collaboration with the UK Centre for Greening Finance and Investment, we are going to kickstart, or I should rather say catalyze our work on this particular issue starting in the autumn, where we want to look at the risks arising from climate litigation to financial institutions, but also to the entities that they may hold in their portfolios. And if you are interested in that field and if you want to work with us, please do reach out, because we think this is going to be one of the defining themes in our field over the next few years. So having said that, I'm going to release you. Thank you so much for your attention, and thanks again to all the panelists and to Ellie and Linus for very, very good.